Hello everyone and welcome to this BCLE webinar. My name is Raj Jagdev. I'm a partner at Powell Gilbert in London and I'm here with Chris Mammon from Bond Dickinson in San Francisco, and we'll be talking to you today about developments in AI and copyright, and in particular AI copyright litigation in the UK and over in the US. It's been quite a busy couple of years on this front, hasn't it, Chris?
Oh, absolutely. There's so much going on in both sides of the Atlantic that I'm really looking forward to our discussion today to update everyone about all of these interesting cases.
Indeed, absolutely. Certainly here in the UK, the last 12 months have been particularly busy with a change in government and with our first major copyright trial related to generative AI. We have quite a bit to talk about.
Excellent. Why don't you tell us a little bit about that copyright trial, and maybe for the audience, set up what the trial was and what the claims were, and then let us know how it is developed.
Absolutely. So you'll all be familiar with Getty Images. Getty sues a European generative AI company, Stability AI, headquartered in London, in the UK Patents Court back in 2023, with a panoply of claims alleging copyright infringement based on a panoply of claims, including copyright infringement, alleging that Stability AI used Getty's database of images to train its stable diffusion model, and also based on the output of that model, images generated by stable diffusion that infringe copyright in Getty's stock images. Also attached to that claims related to trademark infringement, passing off, and also database rights, which is a uniquely European form of IP rights around curated databases. And so that was filed back in 2023, and it went to trial just a few months ago, in fact last month in June, an 18-day trial, one of the longest we've had in a while in the patents court, and garnered a lot of attention, certainly in the IP press, but also got a hearing in the mainstream press as well, just because of the subject matter and how on topic it is at the moment. This all happened in the context of a legislative effort to legislate for copyright and AI, and opening up access to data sets for training that was playing out in parallel in the House of Lords at the time.
Let me jump in and just ask an American question. You said this was a copyright and trademark case that was being tried in the patents court. Can you tell me a little bit about
Yes.
The court jurisdiction and how this case ended up in the patents court?
Of course. So I say the patents court. The patents court is our general IP court. So in the UK court structure, or in the English court structure, I should say, we have the Chancery Division, and within the Chancery Division we have specialist courts. One of those is the Patents Court, which, despite its name, is for all IP-related disputes. And so copyright, trademark, design rights matters all go before the Patents Court as well, and its specialist judges. All of the judges in the Patents Court are ex-IP practitioners.
Got it. Thank you. And so I understand that at the end of this trial, there were quite a number of sort of shocking developments.
There were.
Yeah, go ahead.
Yes, indeed. It's been quite an exciting trial for us. We've been watching it with a lot of interest. It's like watching a soap opera play out, or as interesting a soap opera as you can get in a high court trial. So I put together some slides that summarize or simplify the claims brought by Getty and how they changed over the course of the trial. So I'll just bring those up. So you can see at the beginning of trial, Getty pursued 6 main heads of claim. So it was a primary copyright infringement claim based on the input to the Stable Diffusion model. And this is Gessi alleging the use of its images for training the Stable Diffusion model. Then you had the output claims, also primary copyright infringement claims, and this was Gessi alleging copyright infringement by way of the synthesized images generated by Stable Diffusion, copying substantial paths of Gessi copyrighted works. You then had a secondary copyright infringement claim, which I've called in the slides model as an article. And this was Gessi alleging that the Stable Diffusion model itself is an article within the meaning of the Copyright Design and Patents Act, and is an infringing copy, and therefore distributing that model or importing it into the UK constitutes copyright infringement under the Act. And I have some slides that I'll come on to later on that delve into that a little. And then we have the database right infringement claim, and this is intrinsically linked to the primary copyright claims, and we'll see that in a second. Trademark infringement, and this is because some of the images output by Stable Diffusion actually also included Gessi watermarks or synthesized versions of the Gessi watermark. And then there was a catch-all passing off claim at the end as well. So that was at the start of trial. By the end of trial, Gessi dropped its primary copyright infringement claims and the associated database right claim. So for the input claim, it turned out through evidence that most of the training, if not all of it, happened outside of the jurisdiction, so outside the United Kingdom. In evidence, Gessi adduced that actually some of the training happened in Dubai and possibly in other jurisdictions, but there was an evidential gap. Gessi wasn't able to cross-examine all of Stability AI's witnesses. Some of them had since left the company and weren't available for cross-examination. And so, as a pragmatic measure, Gessi Images dropped that claim. So Gessi also dropped its output claim, and that was because during the course of trial, Stability AI updated the Stable Diffusion model such that certain prompts would not generate works that Gessi alleged infringed its copyright. And so to understand the context of this, it's helpful to know that Gessi in generating images from Stable Diffusion as exemplars for trial and for its claim used quite specific prompts, and it was accepted in evidence by Stability AI witnesses that some of these prompts, because of their specificity, would result in images that would be similar to some of the images in Gessi's stock library. So Gessi Images also dropped its primary copyright infringement claim based on the output images from the Stable Diffusion model, and that's because Stability AI updated the prompt permitted for the model such that the images that Gessi alleged constitute copyright infringement were disabled. So it's no longer possible to generate that class of image using the model. And so effectively, Gessi got the relief that it would be seeking a trial, and so there was no merit in further pursuing those claims. And so it dropped that limb of its claim. And also the database rights claims fell away as well because they were intrinsically linked to both the input claims and the output claims. What remained at the end of trial is the secondary copyright infringement claim, which is perhaps the most interesting from a legal perspective. And this is where Gessi has alleged that the Stability Diffusion model itself is an article and infringing copy, and the trademark infringement claim based on the generation of images using Stable Diffusion that synthesized the Gessi watermark. And of course, the passing off claim remained as well. It might be helpful, Chris, to show some examples of the images complained of, just to set the scene a little bit. And so I've put together some slides where I've captured some choice examples that might be of interest to viewers and listeners. So first up is an example from the primary copyright infringement claim based on output images. So on the left is a Getty image, the original image of an artist at an award ceremony. On the left is a synthesized image from the Stable Diffusion model, which has a synthesized version of the same artist holding what look like two different trophies. One is the same, one is not, a similar backdrop, and in the same suit. So you can see, at least at on an initial analysis, the similarities between them. So moving on to a sports image. Here we have Jurgen Klopp, and on the left again you have the original image. Here it has the Getty watermark, and you have Jurgen Klopp, a football manager, holding a football shirt. And then on the left, on the right, you have a synthesized image. Now it's the same person, or at least a synthesized version of him, with a different shirt. But you can see there, and I've expanded this in the little breakout image below, just the beginnings of a synthesized Getty watermark. Now here's an image that might be more familiar to viewers. So Chicago Cubs on the left, and that's the original image with the Getty watermark credited to Gregory Seamus. And then on the right, you have a synthesized image of the Cubs again. And this time you have a much clearer synthesized version of the Getty logo and watermark. You can see that it's corrupted on the right-hand side, but you can still just about make out Getty images, but the credit line is quite garbled.
So it's interesting that the Getty Images watermark is relatively clear compared with the garbled uniform numbers on the players' uniforms, which don't represent alphanumeric characters at all.
Indeed, that's right. It is quite interesting, that, and I understand, reading through the legal submissions, that there's quite a bit of cross-examination on exactly this point, and some of the Stability AI witnesses acknowledge that this is a known issue in the Stable Diffusion model, and generally in relation to training on images that contain watermarks. Here are some examples of the trademark infringement images that were used, and here you just have images generated straight in Stability AI without reference to an original image. But you see here that these generated images have very clearly a Getty Images watermark on them. And again, the Getty Images text is quite visible and legible, whereas what would be the credit line below is quite garbled. And finally, here's another example of two purely generated images with the iStock watermark in the background, iStock being a Getty trademark, and in both instances you have it fairly legibly recreated in the background. So hopefully those help set the scene and give a flavour for the types of copyright infringement, trademark infringement, infringements complained of by Getty.
So has there been a ruling in the claims that remained by the end of trial?
No, not yet. And so judgment was reserved, not surprisingly, after an 18-day trial. We expect to have judgment at some point this year. And so before the end of the year, there ought to be a fairly substantive judgment, I expect, dealing with the issues that remained. It is slightly disappointing to see the primary copyright claims fall away in the way they did. I personally was quite interested to see what the court would make of the jurisdictional issue. I think it was always generally known that the model was perhaps trained, at least in part, out of the jurisdiction. And there's an interesting policy decision there, or policy issue there to consider, where models generally, typically, are trained not just out of a jurisdiction, but across multiple jurisdictions, but equally are accessible in multiple jurisdictions, in this case, including in the UK. The reason that the claim was brought in London, not only because Stability AI is headquartered in London, but also because it's possible to access the Stable Diffusion model via a web browser in the UK and generate images. And so there ought to be a way of enforcing your intellectual property rights in that scenario. But exactly how that's framed is still somewhat elusive, and is the subject of not just this case, but also many other cases across the world, including over on your side of the Atlantic.
Yeah, thank you, Raj. Before we move over to the U.S., at the beginning of your presentation, you made some comments about some pending legislation being considered by the House of Lords, and I'm wondering if you could give us a little bit of an overview and maybe an update on what kind of legislative proposals are pending.
So no longer pending. It received royal assent in mid-June, actually during the Getty Images trial. So this was the Data Access and Use Bill that was first proposed by the last Conservative government. We had a change of government just over a year ago with the Labour Party coming into power. They dusted off that bill and reintroduced it with some amendments. Now, that bill actually had very little to do, or nothing to do, with copyright and AI. It was primarily concerned with opening up access to business data. So we have an open banking initiative in the UK and in Europe where banks and finance houses are obliged to share customer banking data, if requested by the customer, with other third parties to enable new businesses and opportunities, applications, services to be offered to end users. And so that's facilitated a plethora of new banking services, innovative banking services, automated credit checking as well, that is more tailored to individuals. And so part of the ambit of the Data Access and Use Bill was to open that up to other sectors outside those within the initial scope of the Open Banking Initiative, to other financial institutions and non-financial institutions as well, so that the sort of new innovations and an industry that grew up around open banking can also be cultivated in other business areas. And there were other bolt-on provisions around the GDPR and data subject access rights. But AI, generative AI, is really front and center in people's minds at the moment. And with the passage of this bill to the House of Lords, a significant amount of time of debate time was dedicated to discussing the issue of generative AI and compensation for artists. And this dovetails with a consultation opened by the government proposing a mandatory licensing regime. Well, I say mandatory licensing, more a default opt-in scheme where it was proposed that AI developers ought to be able to use copyrighted material for training models, subject to provided that copyright material is not opted out of such training, but with a compensation regime for artists to compensate them for works that are used in training models. Now, there was no real flesh put on the bone of that, no real discussion about how that compensation model might work. I mean, there are already licensing agencies and schemes in the UK for music and other sectors, for collective licensing, that is, and it was speculated those might be used to enable this. But the fact that consultation was open at the same time as the passage of this bill through Parliament led to convergence of the issues and quite a bit of debate. There were provisions in the bill that touched tangentially on this in terms of the open access aspects of it. They were perhaps misconstrued as being applicable to copyright and AI. They weren't really, but they certainly prompted a debate on it. And so the bill passed. It is now an act of parliament. It received royal assent, and it quite firmly has no aspects or no provisions in it that touch on copyright and AI. But there is a live consultation at the moment being run by the UK IPO and also other departments in the UK government around the issue of generative AI and whether or not AI companies ought to be able to use copyright material for training.
Well, thank you very much, and I think that's a good segue to talk about what's been going on in the United States over the last year or so. You talked about on the Getty Images case there being considerations of both inputs and outputs, and I like to use a graphic to sort of help people think about this. So
I like the black box.
Yeah, so this is our black box of AI in the center, and it includes considerations on the left of the inputs to the black box, which sometimes include copyrighted material, but include text, images, music, other kinds of inputs. And then on the output side on the right are generative AI outputs. And as we saw, the presentation from the Getty Images case included some considerations of both of those. And and what we have really developing in the US right now is a number of cases on the input side. There are, at last count, more than 40 lawsuits pending in the US dealing with copyright infringement and related types of claims focused on claims made by copyright holders or other rights holders about their data being used as training data. Why don't I actually pull up a slide to show these?
That'd be great. I understand there's a magnitude more in the US than there are in the UK and in Europe, and you can see that very nicely in this graphic.
Yes, and so there are emerging pockets in the Northern District of California, here in San Francisco, San Jose, and Oakland, in the Bay Area, and then in the Southern District of New York also has a significant number of cases. There are also a few pending in other courts around the country, but the ones that have really advanced the farthest and have resulted in some rulings on the fair use doctrine are the Bartz versus Anthropic case pending before Judge Alsup here in San Francisco, as well as the Kadri versus Meta case, which is pending before Judge Chabria, also here in the Northern District of California. And
were there recent judgments in those cases, Chris?
There were some partial summary judgments issued in both of those cases recently on the issue of fair use. On June 23rd, in the Bartz case, Judge Alsup issued a ruling finding that as to the training data, there was fair use. And then 2 days later, in the Kadri case, Judge Chabria issued a ruling also finding there was fair use, but signaling that that may have been limited to the particular facts presented in that case. And so to explain that, let me walk through the fair use factors and how they were applied in the two cases. So the fair use factors are set by statute in our Copyright Act. There are four factors that are taken into account in determining whether a particular act of copying a copyrighted work is subject to the defense of fair use and therefore non-liability for that use. The four fair use factors are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect on the potential market. And let me say a little bit more about each of those. The purpose and the character of the use includes, broadly speaking, two main considerations. One is whether the use is a commercial use or is a non-profit use, such as an educational use or research use. Another aspect of the first factor is whether the use has been transformative. It's often illustrated by saying the use is a parody of the original or something like that.
So transformative in an IP sense as opposed to a regular sense.
Yeah, I'm not quite sure what you mean by a regular sense. You know, IP is regular, but transformative in an artistic sense, an IP sense, as opposed to a technical sense. You know, the Copyright Office has articulated, quoting the Supreme Court, that a transformative use is one that alters the first use with new expression, meaning, or message.
Yeah.
And so that's the concept that we're looking for there is, you know, commercial, non-commercial. Is it transformative in the sense of, is there a new meaning or message? The second factor, the nature of the copyrighted work, is easy to think of in terms of, is it primarily a creative work, such as a novel or a musical composition, or is it something that's primarily factual, such as news reporting? The third factor, it turns out, is really interesting and tricky to apply in the generative AI context. It's the amount and substantiality of the portion used. Sometimes some people argue that this should be considered at the input side of the black box, where the entire work is ingested. Others argue that this factor should be considered on the output side, because that's the side where the work is made available to or exposed to the public. And in any particular generative AI output, most of the time, setting aside memorization problems, which we can return to, but most of the time, the output is going to contain only an infinitesimally small representation of each work that was used as training data. And so how that question is defined determines its answer. The fourth factor, the effect on the market, is generally considered to be the most important factor among the four fair use factors. And the core use case of that is where there is a direct copy that's being sold as a knockoff on the market, and there's a one-to-one market displacement for the original work. Clearly there's a direct impact on the market. In the context of AI, unless you have an example of a memorized output that's being offered in the market in direct competition with an exact copy of the input, that is relatively less common. What's more common is that generative AI outputs may be in the style of a particular artist, or in the same genre in the sense that even if it's not styled after a specific artist, it's replacing some part of the market in the genre. There's also a concern that flooding the market with hundreds or thousands or tens of thousands of AI-generated works that are creatable on demand will reduce the market value for each of the human-created works that are input as training data. And so this is a factor that the two judges in the Bartz and Kadri cases really disagreed significantly on. In the Bartz case, Judge Alsup limited his analysis of this fourth factor to one-to-one copying and said, as to the use of training data, there's not really this one-to-one copying except in rare instances, and so he found that there was not an effect on the potential market. On the other hand, Judge Chabria in the Kadri ruling leaned into these more market-focused impact on the broader market as a whole theories, and said, these are some theories that were articulated significantly in a pre-publication version of a generative AI training report from the Register of Copyrights that was issued in May of 2025, articulated some of these alternate economic theories for the fourth factor. The report itself was issued the day before several senior officials at the Copyright Office were fired, and so far a publication version, full publication of that report has not been issued. That said, Judge Chabria indicated there's some merit to exploring those theories, but they weren't fully presented in the summary judgment motions before him, and so he couldn't enter a finding to that effect. So let me pause there. It looks like you might have a question.
I do. I do, but I was wondering about the third criteria for fair use and what consideration has been of that. I mean, I guess perhaps not in the summary judgments applications because they were perhaps more focused on the effect on the market. But how does the third criteria play out? Because it's quite a difficult topic to address in the context of AI and especially output images. One of the points that Stability AI raised in defense is that the output process or the process of generating an image is essentially stochastic, and so you can't really predict with any certainty that you're going to get the same image out with the same prompts unless you are actively training the model by continually prompting it in the same way to get the same image, in which case you're then perhaps biasing the model. It's a difficult balance between content creators on the one side and AI models on the other.
Yeah, exactly. I mean, there's a lot of complexity involved in this factor. One of the arguments about the application of this factor to the input side is the argument that the training data being input into the system is an intermediate copy that is not being exposed to the public or made available to the public, and therefore shouldn't be considered. There are counter arguments that have been articulated to that. To the effect that how this information, once it's tokenized or otherwise adapted into the AI trained model is analogous to being made available to the public in that the model is available to the public. But on the argument that the outputs themselves, it's unpredictable exactly what's going to come out. The portion that's going to be used in any particular instance is likely going to be fairly small, though the Copyright Office's report sort of refers to this as sort of the Goldilocks analysis, in that the desire is to have it just right. You don't want to have too much copying and too much identicality so as to skew into memorization, but you don't want to have it be too far afield from the training data to randomized, because then the outputs won't be sensical or will be too chaotic. So you want to get it just similar enough that people are happy with it. And I think it's an ongoing problem, and we'll see more analysis of that question, and in both the technical analysis as well as the ways to apply that to the legal analysis.
So I'm curious about the input side. I'm assuming that in the cases that are pending in the US, where there are claims in relation to the input and the training of the models, those models are trained domestically in the US as opposed to out of the jurisdiction. Do you have, or put another way, do you have the same issue that Getty Images faced in the UK case around the training happening out of the jurisdiction?
Yeah, so I'm not aware that jurisdictional issue has come up in the same way that it arose in the UK's Getty Images case. Yeah. I honestly haven't dug in to see if that's a difference in the jurisdictional application of the way our laws are written, or if it's come up and the training has been established to have been done in the US. I think it is something that we should continue to keep an eye on as different countries seek to engage in economic policy around the AI boom, and may adopt laws that are more encouraging of AI training within their jurisdictions. That could be an emerging point of both comparative law and economic policy.
Absolutely. I mentioned earlier that there is a proposal in the UK to permit commercial text and data mining. So text and data mining has been permitted in the UK and in the European Union for a while now, at least for a couple of years, for academic and research purposes. And there's an interesting nexus there with current generation and prior generation generative AI models. Stable Diffusion itself started its life as a university project at a university in Germany, and was then acquired and rolled into a commercial project, or product rather. But that initial training was done at a university, in a university lab, and no doubt benefited from the text and data mining exemption for research purposes. And of course, that's the story of modern development and innovation in the computing space. Very clever lab projects that then become commercialized. And that's a balance also, and a transition that I think we might see a light shone on in the context of these matters.
Absolutely. It's something that is part of the first fair use factor in the US, but I think it was brought into much more stark contrast in the debates this summer over the commercial exemption for text and data mining that was under consideration by the UK government, leading in part to a group of recording artists issuing a silent album earlier this summer, which was, as I recall, 45 minutes of absolute silence, suggesting that if their position was that if the government adopted this commercial exemption, this recording would represent the future creative output in the UK.
Of the UK creative sector, absolutely. I mean, this issue galvanized the creative sector in a way that hasn't really happened in a while. I mean, I guess analogous to the writers' strike over in the US a few years back, which also related tangentially to generative AI, or at least the use of their image rights for AI future content that might be AI generated. It's a fascinating area, but of course, we've seen a transition in the recent past from one form of content generation or content consumption to another, linear television to on demand, and that shook up the creative industry, at least on the film and TV production side, and we're seeing the long tail effects of that today.
This is absolutely right. This is an area where much has been said about the potential of AI tools to turbocharge the creative sector and to be used alongside human creativity. And this is something that is important in remembering as part of setting policy, is that it's not entirely diametric opposition between the creatives on one hand and the generative AI platforms on the other hand. But there are a lot of creative artists who use these tools in enhancing or developing creative outputs that they're involved with, and that we need to make sure as we move forward with policy that there are not unintended results about this encouragement of developing new markets and new creative outputs.
I think that's absolutely right. In my mind, a canonical example of an AI tool used by creatives is in the graphics sort of sector, where Adobe and others have some fantastic tools to help enhance graphic designer workflows, and these tools are used widely and are loved by graphic designers and have been integrated into their workflows quite seamlessly. And I think the policy objective is really to strike a balance between protecting the rights of creators against the effort and the skill expended in creating those works. There is that threshold that we have in each of our jurisdictions, and I think it is the assessment of crossing that threshold that crossing that threshold isn't quite right. We have thresholds for whether or not copyright subsists in a work based on our own respective tests, author's own intellectual creation in the European Union and in the UK broadly. And there is a debate and a balance to be found between how that is assessed in an AI world where there are tools that can be used to automate processes. We've always had an element of that in the UK, and the UK CDPA, of course, has recognized it with the concept of computer-generated works, which has been a feature of our copyright legislation. And we've always had an element of that in the UK. The Copyright Design and Patents Act, which is dated 1988, includes a provision for computer-generated works and recognizes from an authorship perspective that the author of a work that is generated by a computer is the person instructing that computer program in the generation of that work. And for the most part, that provision applies and works nicely in an AI world as well. But the exercise of skill and judgment in the use of a computer tool, for example, using Microsoft Paint and creating an image pixel by pixel, is very different to pressing a wizard button in whatever the latest incarnation of Microsoft Paint is to create a a whole scene. But then perhaps the expression of intellectual creation is in the prompting of that tool, and I think there's a debate to be had there.
Absolutely, and for now, in the U.S., the Copyright Office has determined that prompting does not provide sufficient creative input for the prompt engineer to be deemed entitled to a copyright of whatever comes out of a generative AI tool. I want to make an observation and a question about the 1988 law in the UK, and then I think we're probably out of time. We could probably keep going all day, but I'll make these 2 points and then give you the last word. So, as I understand it, the author of a computer-generated work under this provision of the UK law is actually deemed to be the person by whom the arrangements necessary for the creation of the work are undertaken. And it's not immediately clear to me exactly who that's referring to in the context of generative AI. And so I'll close with a question to you and the last word. Has this law been applied in the context of generative AI?
So, not that I know of at the moment. Of course, the Getty case is Getty Images asserting copyright, alleged copyright infringement of its images by Stability AI. What hasn't played out yet in the UK courts is a content creator asserting copyright in a work generated by way of an AI platform or an AI model. And so I don't think this has been tested yet. I'm not aware of any cases that are currently in the court list that might, but it's certainly an interesting thing to keep an eye out for. And you're quite right. It's a difficult, it's a thorny area to navigate in a world where actually the instructions are coming perhaps not from the actual prompter, but from the model itself.
Indeed. Well, thank you very much for including me in this discussion today, Raj. I've really enjoyed our conversation and look forward to continuing the conversation.
Thanks, Chris, and thank you all.